Anytime you're doing any kind of legal writing, whether it's a motion, an appeal, special exceptions, writing a petition, whatever it is, you have to ask yourself, what am I trying to accomplish here? For any given sentence, it's going to be one of two things. Either you're trying to make sure that you've included everything that you need to include so you don't wind up losing your case because you didn't put something in your pleadings or in your motion that you should have, or are you trying to be persuasive? Now, in the vast majority of things that you file, whether it's a motion or whether it's an appeal, you're trying to do both at the same time. For example, a motion for summary judgment, which I think I've got a video talking about a little bit. But a motion for summary judgment is basically asking the judge, hey, there's really even if things are exactly like the other side says they are, legally speaking, they don't have a case, and so we should win, and there's no need to waste a whole bunch of time on a jury. Now, if you do that, there's a lot of things that have to be in a motion for summary judgment, and it's not always common sense what needs to be in there. But at the same time, you also have to persuade the judge. And generally speaking, you're best if you separate them completely. What I like to do is I'll have a section at the very beginning of the motion for summary judgment that most other lawyers don't include, that just very, very plainly and very clearly says, here's what I want, and here's why we should get it, without even an effort to preserve any sort of error or to preserve what I need to preserve in the motion in order to be legally sufficient. I'll have other sections later on where I do that, but I want to make sure I'm very clear. First of all, it's easier for me if I'm very specific about this is the section where I'm preserving error, and this is the section where I'm putting my legal arguments in a form that's going to stand up on appeal. The thing is, particularly in the context of a motion for summary judgment, making sure you cross all your T's and dot all your I's, such a way that you'll stand up on appeal isn't always the most persuasive. It could be long, it can be boring, it could not necessarily be put in any kind of an order that a person would understand. And that's why I think it's always very important to put your most persuasive, your most just plain talking, common sense language in a section at the very beginning. Judges are people too, and they don't know everything about the law, and they certainly don't know anything about your case. You'll spend weeks learning about a case, learning about the subtleties, and you've got to not only, in a sense, educate a judge, but also persuade them in a matter of minutes, generally speaking. You can definitely lose a judge in less than an hour. I would think very frequently judges, I don't know if I'd say they make up their mind, but they certainly begin forming mental impressions of a case very quickly. And if you give the judge a good explanation, a clear explanation, and a fair explanation early on, and you're the party that the judge looks to figure out kind of what's going on a case, you're setting yourself up for success.